Starting with the State of Ohio versus William Harrell. There are 6 case numbers to this on this appeal, starting with 30104 through 30109. The state has waived its oral argument, so we will just be hearing from Mr. Chapman on behalf of Mr. Harrell. You'll have 15 minutes to present your argument, Attorney Chapman, and as you know, the arguments are recorded, so we ask that you keep your voice up and stay at the podium there, and refrain from using the names of victims. I don't believe there's any children in this case, but I can assure you that we've all read the briefs and we're prepared to proceed if you are. So, Attorney Chapman.
Good morning, Your Honors. May it please the Court. My name is John Chapman, and I represent Mr. Harrell. Your Honors, I think that, and I intended to say this even before the events of the past couple of weeks, there's in my view, and I think in the community view, a crisis of faith in our system. One that I think is felt keenly by members of the community that are going through the system, but also people who are observing the system from the outside. In this particular case, we raised 3 issues on appeal. One of them being that the trial judge should have allowed my client to enter a no contest plea. One, that the trial judge should have allowed my client to withdraw his plea and proceed to another trial. And that the trial attorney in this case was ineffective in arguing on my client's behalf. In all those things, or at least in those first 2 arguments, I think that it comes down to an abuse of discretion and whether or not the judge should have taken the actions that she did. In order for us to show that there was an abuse of discretion, there has to be a showing that the actions of the court were unreasonable, arbitrary, or unconscionable. I don't believe that unconscionable or even unreasonable might apply, but certainly arbitrary is, I think, established by some of the discussion and back and forth that are in the facts and in the transcript between the court and my client. According to State v. Beasley, arbitrary means that the decision is made without consideration of the facts. With regards to the no contest plea, there was no consideration of facts or the circumstances particular to this case. The plea which the court had engaged with my client and had discussed his entering into additional plea negotiations after the trial had commenced, he then did so at the court's behest. When they came back with an agreed upon plea as the court requested, then ultimately the judge summarily rejected that plea and stated that she was doing it because of what she had heard and what she believed the evidence was going to be. This was on the second day of trial. The only thing that had been presented at that point were opening arguments. There had been no witnesses, so there were no facts in front of the court for the court to consider in whether or not to accept or reject that plea. There was only argument and the court's expectation of what it expected that evidence to show. Just by stating that she expected the evidence to show things shows that the court had already formed an opinion as to what those facts were going to be. That is, in my view, the very definition of arbitrary. She in this case formed an opinion about the facts of the case based upon no facts being given. So I think that certainly I believe that when it comes to whether or not my client should have been allowed in a no contest plea, I think the comments by the judge and certainly led to that idea that in this case she was acting in an arbitrary fashion. She had already made up her mind as to what she was going to allow in terms of that plea.
That's an interesting argument because Beasley doesn't say to consider the facts and evidence. You know, when somebody enters a no contest plea, initially there's no facts and evidence before the court. Just as has to consider the facts and circumstances of the case. And at the point that the judge rejected this no contest plea, I believe opening statements had concluded it was the start of the second day of trial.
That's correct.
So she certainly had some things, facts to consider, or at least arguments of counsel to consider. I believe she said, based on what I've heard and what I expect
considering the circumstances of the case, you have to consider the point that they're at in the case. Typically, when someone tries to enter a no contest plea, the court will hear from the parties why the no contest plea is going to be entered. As someone who's made those arguments before the court, typically I will explain to the judge that, perhaps there's a civil liability issue or some other reason why they want to do that. In this case, there was no presentation of that. The court summarily rejected it based only on what the court had heard in argument at that point. There was no opportunity by the state, which had negotiated that plea, to state why the state believed that that plea would be appropriate. There was no opportunity taken by the defendant to say, this is why I feel that this plea is appropriate. The defendant's attorney, which all of these things lead into the question of whether the attorney was ineffective, because the attorney never engages at all in any of these discussions. It seems, as I read through the transcript of these back and forth discussions between the judge and my client regarding the plea and some of these other matters that are before the court, I kept waiting for the attorney to make these statements that I, as attorney, would have made in their place, something to say why this plea is appropriate, and later why the withdrawal of the plea was appropriate. And yet the attorney is silent throughout all of this process, or at the very least just chimes in very, very little. It does nothing to add to or enhance his client's position. So I think that when we talk about without consideration of the facts, and that you're wanting to consider all the circumstances of the case, I think that the judge never takes the opportunity to consider those things, just summarily rejects it out of hand, even though the judge had essentially initiated these additional plea negotiations during trial by asking the defendant or telling the defendant or negotiating in some way with the defendant to by the court making promises to the defendant that if he engaged in these negotiations and they came up with a plea, the court would give him some kind of a benefit later on when it came time for some sort of an early release or opportunity to get out. I think that given that the court was taking an active role in this, it certainly was incumbent upon the court to at least put on the record, or allow the parties to put on the record, why they felt the no contest plea was appropriate. Then the court could then address those considerations in making that ruling, and perhaps have made a different ruling. If the judge heard a good, compelling reason, perhaps the ruling would have been different. And perhaps we wouldn't be here with an appeal today if my client had been able to get the plea that he initially negotiated. I think that that argument leads into the next argument of whether the withdrawal of plea was appropriate. Because all of these things go to my client's belief, and it is a sincere belief. But if the court has reviewed the record in this case, the docket entries, including ones that have been ongoing since this case concluded, it's clear that Mr. Harrell believes sincerely that he was somehow a victim of the system. He believed, and he stated continuously through this process, that he believed that the state was biased against him and was using material that it had illegally or somehow unethically obtained from his attorney, information that he had shared with his attorney in their prosecution against him. He expressed concerns about his attorney, expressed concerns about the court. And so the question that ultimately goes to, was there a reasonable basis for him to seek to withdraw his plea? I think it should be compelling, I think, the way that whole process took place. The court entices him and engages with him and ultimately negotiates with him to enter into a plea bargain. He makes the plea bargain with the state. They come back, the judge rejects that plea bargain, and then in that back and forth with him, you can see the frustration or perhaps the concern on his part that he needed to do what the court wanted. I think he even used those words.
Counsel, did the court ask him if he felt pressure at all?
The court, when you do a plea, the actual plea itself, the court asks that question. The court asks if your plea has been coerced or someone has promised you anything in exchange for your plea. He says no during the plea colloquy. He says, he answers that question no, but...
Did that happen once or twice?
I believe that it happened I know it happened during his plea. I'd have to look back at the transcript to see if there was another time. But there is that normal plea recitation of things that the court goes through and asks the defendant to respond to each of those things. You know, whether they're satisfied with the performance of their counsel. He was also asked that and said that he was. But the issue is not, the question is, would someone who is feeling coerced by his counsel, by the state, and by the judge answer those questions truthfully? Or would they feel that they have to answer a particular way in order to satisfy the court? He says that I will take, I'll do this plea if that's what the court wants. And he's showing, I think, that he was feeling that pressure from the court to enter the plea. He was feeling unserved by his attorney, and he was feeling, a bias from the state. He did not feel that he was getting a fair trial. So what would we expect of him to say when he's asked those questions, when he's making that plea? If he's already being coerced into making the plea, then that coercion would also inform his answers to those questions that the court asked. I think that given his concerns earlier in the case that have been expressed probably throughout the case, I think perhaps the court could have made more of an inquiry in order to put additional facts or statements on the record by him that this was a voluntary plea. I think that it's telling the next set of facts, which is once he's removed from the court and he's back at the jail and he's free of influence from his attorney and free of influence from the prosecutor, free of that feelings of influence from the court, what does he do? He writes a letter to the court asking to withdraw his plea. He doesn't go through his attorney, which he could have done. He could have asked his attorney to file that motion, but it's compelling, I think, to show that he is bypassing the attorney and going to the court directly to try and get the relief that he's seeking. The court...
Did he do that immediately, or if I recall, it was a couple of weeks?
It was, I believe this was done around on the 4th or 5th of May, and then the letter was sent on the 17th of May is when it was retrieved by the court. I don't know when it was sent because things coming from the jail don't always get right to the court, but I would assume it would be within a week or so of this. And he certainly expresses that he felt, that he expresses in his letter that he felt that his plea was coerced. He expressed that, he wanted to withdraw his plea. I think the court at that point had an opportunity before the pre-sentence investigation was well underway. It was more than a month before the sentencing ultimately occurred. The court could have, and I think probably should have, brought him in for a hearing in order to fully explore that. Ultimately, the court did have a hearing on his request to withdraw the plea, but it was done at the sentencing, when the process has already reached its concluding stage.
His motion was basically coercion and pushed by the court and counsel. It wasn't based on newly discovered evidence, or obviously we don't have the argument that it was a blanket policy. What's in the record concerning coercion and by the court or?
Well, first of all, his feelings that he was being coerced are throughout the record. This is not something that he simply goes back and voices for the first time. He states it from almost the outset of the transcripts that I provided to the court of the day that he entered his plea. He's talking about that he's not getting a fair trial from the prosecutor. He feels that the prosecutor is somehow using his attorney-client communications against him. He's expressing concerns about his attorney. He's expressing concerns about the court.
Counsel, excuse me, when you say he's talking about and he's expressing concerns, what specifics are he laying out that we'll be able to read in the record?
He's stating that specifically he's stating that his attorney-client communications were somehow compromised with the court. I don't think he ever gets specifics into how they were compromised, but he's saying that statements that he made to counsel that ultimately would have only contained information that he believed would only have been available from his statements to counsel were ultimately being used in the arguments against him. And he specifically, I believe, references statements by the prosecutor during the opening statements. He talks about that, and then he also talks about some of the other things that the prosecutor had made, statements made during pretrial, I guess, hearings and such, that he believes contained information that could only have been shared or obtained by listening into those communications. And with regards to the court's direct communication with him, I think goes above and beyond what I would normally expect to see in that situation, that the court is engaging him in plea negotiations, which I believe I cited a case to state that could be considered coercive. And
Counsel, on that, and again, I don't have the record in front of me, but wasn't the court merely saying that it wasn't going to accept what the negotiated plea between the state and Russ?
it goes a bit further than that, because what the court was saying was, he expresses concern to the court, and again, I want to remind your honors that all of these are coming from communications between him and the judge. His attorney is not participating in this at all or advocating for him on any of these issues. But what happens is that he talks to the court about the fact that there was some sort of a plea offer and he wanted to make a counter offer, and there's a back and forth between him and the court regarding that. Ultimately, the court tells him that if he engages in plea negotiations and comes up with a plea agreement, that the court would then allow him to enter an early reentry program at the end of his sentence. So the court is essentially offering him an incentive or its own term to the negotiations that in order to entice him to enter into those pleas. Then when he comes back with his plea, the court acting, at least perhaps in his own view, but at least in some way, the court doesn't accept the plea and says, if you're going to do this, it has to be a plea of guilty, which means the court is now directly speaking with him about what the court, what the plea will or won't be. So it's a direct directive from the court to him about what what that plea will ultimately look like, what the court is promising him if he enters into the plea, as well as what the court will accept as a plea. Those are usually things that come between the parties when the parties are in negotiations. So I think those have the trappings of a negotiation by the court, at least on some aspects of the plea.
And in the facts of this case, what is the prejudice to your client by entering a guilty plea instead of a no contest?
That's, I think, not reflected in the record, because there was never an opportunity or an explanation in the record as to why the state agreed to a no contest plea and why his counsel advised him, presumably, to take the no contest plea. I think it would have been very helpful for the court to make that decision if we knew those things from the record. But these are breaking and entering cases, so presumably there would be potential civil liability, if no other reason, for various forms of restitution that could be owed to the different parties.
Okay, I've let you go a little bit over.
Appreciate that.
Very interesting responses to the questions. We thank you, Attorney Chapman, for appearing today and providing us with your argument. The court will take the matter under advisement, issue a decision in due course. Of course, you will receive a copy of the decision on the day it's released, and the opinions are also posted